Let's continue with our discussion. We were discussing Article 19(1)(a), that is right to freedom of speech and expression. We had seen what was Article 19(1)(a). We had seen certain inferred rights that the Supreme Court has declared under Article 19(1)(a), and then we had started our discussion on certain restrictions that are there, that are placed on our freedom of speech and expression. Out of those restrictions, we had discussed, the last part of our discussion was contempt of court, that how contempt of court is considered to be a restriction under Article 19(1)(a). So what is contempt of court? The power of the court that the court has under Article 129 and Article 215 of the Constitution. Article 129 dealing with the Supreme Court and Article 215 dealing with the High Court. And both these provisions declare the Supreme Court and the High Court to be the court of record. What is the meaning of court of record? There are two basic powers that are given to the court. First, the court becomes a matter of record. All the proceedings that are there in the court, they are the matter of record, and they can be produced as evidence in any other court. Similarly, the court of record also means that it gives a power to the Supreme Court and the High Court to punish an individual in its contempt. To punish the individual in its contempt if the court finds that there is a case wherein an individual has in any way tried to undermine the authority of the court, scandalize the judgment of the court, or interfere with the due course of justice, or for that matter does not follow the decree, the orders given to the court, or any kind of undertaking that is submitted by the individual to the court. In that case, the individual is likely to be punished in contempt of court. We had also discussed the 1971 law, which was enacted by the Parliament, Contempt of Court Act, which provides for two classifications of contempt: criminal contempt and civil contempt. We had discussed what is civil contempt. We had also discussed what is criminal contempt. We have also seen that under Article Section 16 of the under Section 16 of the law, the court it is the contempt of court power that is there. The contempt power is to protect the seats of justice, not the judges, and hence any individual can be punished any judge can also be punished in the contempt of his court. I gave you an example for this. What happened in the last 2-3 years, wherein one of the High Court judge of Kolkata High Court, he was punished. Why? Because he did not accept an order that was given by the Supreme Court, wherein he was transferred to some other court, and that is the reason why he was punished in his in the contempt of court. He had to serve a period of 6 months. Clear? Next. So this was the first discussion here, that was contempt of court. Next we come to our discussion on sedition. Section 124 of the IPC. Section 124 of the IPC. So, why are we basically discussing Section 124A of the IPC? Yes. Why are we discussing this provision here? Why is there a need to discuss this provision here under Article 19(1)(a)? Why? Because in the recent years, if you look at, that means if you go back to the last around 10-12 years, there has been number of cases that has been registered, and it basically has alleged an individual to have committed something called as a sedition. Now, something called as sedition. And there are two views that are present currently. First is a view wherein the sedition law is considered to be a violation of fundamental rights, because now there is a very prominent view. There is very prominent view among among individuals, specifically when it comes to the liberal group of our the liberal group of our what you can say of our society, wherein sedition, the laws that are there, the law of sedition is considered to be a violation of fundamental right, and accordingly it has been urged to the Supreme Court to declare the law to be unconstitutional. On the other hand, there is a different view also. The different view is that sedition is something that is absolutely necessary. A law of sedition is absolutely necessary, and hence it should continue. It should not, there should not be any amendment to the law, and it should still continue, and it is not a violation of fundamental right. Why? Because our fundamental rights are always under reasonable restriction. They are not absolute rights. So because they are not absolute rights, hence we need to continue with the law of sedition, because it is something that will it is something that is there to protect the territorial integrity, the sovereignty of a country, of our country, and hence we should continue with sedition laws. What you need to understand is that this law has been in this law has been in news for the last so many years. Even if you look at UPSC examinations, this very idea has even been asked once. But it has been almost 5 years since it has been asked, so you can get a repeat question on this. Why? Because for the last so many years, if you look at what happened in JNU, if you look at there was a case in one of the NGOs in Bangalore, and there was a sedition case registered against that NGO. Similarly, if you currently look at it in the current general elections, the Congress party in its political manifesto had promised that if they come to power, they are going to repeal sedition law. Now, they are going to repeal the sedition law. Previously, there has been number of cases going back to certain cases in which if you go to the state of Tamil Nadu, you would find there was a group of individuals led by an NGO who had protested against the nuclear power plant that was installed there, and there was a sedition law that was registered against them. Similarly, if you go back to the year 2010, there was a cartoonist called as Asim Trivedi, and he had to serve a sentence. Though he was under trial, and he had to remain in jail for somewhere around 3 to 4 months. Why? Just because a sedition law, he had come up with some cartoons which depicted the Indian Parliament to be it was a comment on the Indian Parliament, and a sedition law was registered against that individual. Similarly, if you look at in 2016, after the Uri attack, when there was a actress of in South India. She was visiting Pakistan, and when she came back from Pakistan, it was basically under the background of the Uri attack, and there was one of the journalists asked her a simple question: what do you think about people of Pakistan? And she made a comment that people of Pakistan are not demons. And on that particular comment, there was a case of sedition that was registered against her. The first, if you go back to the sedition law, IPC, Indian Penal Code is a British product. It is not something that we have come up with in the post-independence and in the post-constitution period. So if you look at the previous, if you go back to the previous the pre-constitutional era, pre-independence era, you would find political personalities such as Gandhiji, political personalities such as Bal Gangadhar Tilak, they have all been prosecuted under the sedition law. Clear? So first let's start our discussion with what does section 124A actually say. What is the language that is used? Because the language that is there, language is of immense importance here. Clear? So you can write section 124A. What does it say? Or what is the definition that is there? Whoever by words, either spoken or written, or by signs, or by visual representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite, dissatisfaction towards the government, established by law, is punishable with imprisonment for life. That means here underline the term the government established by law. If you go through this definition, it is very clear what is the intent of the law. The intent of the law, the Indian Penal Code 1860 and in the Indian Penal Code of 1860, section 124A was introduced, which means we are talking about the British Indian period. We are not talking about the post-independence period. We are talking about the British India. And in British India, when we say government established by law, what does that mean? It means if you take up any act, which in any way, if you look at the definition says by words either written or spoken, or by signs or by any kind of visual representation. If you take up any act which is in line of or which can be understood as a criticism of the government established by law, it will be considered as an act of sedition. Now, if we go by the logic that the British India that was there, it was an undemocratic state. The logic is, if we go by this, it was an undemocratic state. It did not provide for freedom of speech and expression to the people, and the whole objective of the government that was there, the whole objective was to ensure that any acts that are there, or any speeches or any visual representation or any kind of article that is written in various newspapers, it is not to, or it does not do what? It does not evoke nationalism. Wherein people tend to do what? When people come together and start criticizing the laws that are made by the British, by the British Parliament, or rules, regulations, laws that are enacted by the concerned government. And the law was very much against this. So if you go by the literal definition of the particular law or the definition that has been mentioned under section 124A, we find yes, literally it is contradicting what article 19(1)A of the Constitution says, that is freedom of speech and expression. However, this law itself, this law itself that is there, if you look at its literal definition or what has been mentioned under section 124A, and in 1860 what happened, it has undergone first of all a revision by the Supreme Court, and the Supreme Court itself has upheld the constitutional validity of the law. Why? Or what is the basic idea here? If you look at the literal meaning of the law is that any individual cannot criticize the government that has been established by law. Any individual, any group of individuals cannot do anything which is criticism of the government that has been established by law. Why? Because that will amount to sedition. So any kind of step that is taken by the government, by the executive, that cannot be criticized, or that is not under the phenomena of criticism by the people of India. Why? Because that under the literal definition of section 124A, it would amount to sedition. This goes against the very idea of democracy. This goes against the very idea of fundamental rights. Because if you go back to our previous discussion, we have seen what is fundamental rights or what are fundamental rights. Fundamental rights are those rights that are given to us so that what we have is a limited state. What we get is a government which is not arbitrary. A government which does not deprive citizens of their basic rights. This is the very objective of fundamental rights. But if you look at what section 124A says, literally it is against the very principle of what fundamental right, or the very philosophy of what fundamental right, what is the basic objective of fundamental right. It goes against that very idea, and hence it automatically comes under criticism. If you go back to the pre-independence period, and if you look at what Gandhiji had to say about the law, so Gandhiji was also punished under the section under sedition, and he said it is very appropriate that I as an individual, as an Indian, is being punished under this law. Why? Because I am an individual who is criticizing the state. I do not disagree that I am not criticizing the state. Yes, I am criticizing the state. And the sedition law says government established by law, government not established by the will of the people, but government established by law. And if there is a government which is established by law and not by the will of the people, it is an arbitrary government. It is not a government which has legitimate authority over us. And if I have to be punished, it is very appropriate that I am being punished under a law which can be considered as a prince or a king of all inappropriate laws or all inappropriate illegitimate laws. That is section 124A. Going just by the literal definition or the literal meaning of the law, yes, it contradicts our fundamental rights given to us under article 19(1)A. However, this law, the constitutional validity of the law was upheld in the Kedarnath Singh versus the state of Bihar. Kedarnath Singh versus the state of Bihar, 1962 case. 1962 case. Just listen to me, there is no need to write. There are some important ideas here, I'll dictate that. In the Kedarnath Singh versus the state of Bihar case, this individual Kedarnath Singh, he in a political rally was criticizing the then government, the then Congress government that was there, that was established. He was criticizing them, and now he went to an extent wherein he started abusing the Congress government and the police that was present there. So there was an organization called as the CID which used to exist then. So he started calling them as dogs of Congress, etc., etc. And after the rally, he was arrested, and there was a sedition case that was registered against him. This case went to the Supreme Court, and in the Supreme Court, Kedarnath Singh challenged the constitutional validity of the sedition law under this very idea that it is contrary to fundamental right under Article 19(1)(a). The Supreme Court, in the decision, the Supreme Court upheld the validity of the law. The Supreme Court said that sedition law strikes a correct balance between public order and Article 19(1)(a), that is freedom of speech and expression. The Supreme Court did what? The Supreme Court upheld the constitutional validity of the law. The Supreme Court declared the law to be constitutional, not to be unconstitutional. Rather, it declared that yes, it is constitutional. And further, the Supreme Court said that if you look at the sedition law, what does the sedition law do? Sedition law ensures that there is a correct balance that is maintained between what is public order or maintenance of public order and freedom of speech and expression. However, the Supreme Court, while interpreting the section 124(a), also significantly changed the meaning of what has been written there. The Supreme Court changed the meaning of what has been written. The Supreme Court said that the law should be read as any act of the of any individual, whether it is written, whether it is spoken, any such thing, which excites violence against the state. Which excites violence against the state with the objective of overthrowing the state. Violence against the state, which excites violence against the state with an objective of overthrowing the state. So, no more the term government established by law. No more it is read as a government established by law. It is read as what? It is read as any act or any word that is spoken or written, or any act which excites violence, or it excites violence, eminent violence, not just violence. It's Supreme Court said it excites eminent violence against the state, not against the government, against the state, with an objective of what? With an objective of overthrowing the state. And by doing this, what did the Supreme Court do? Not only did the Supreme Court amend what has, informally. Formally, if you look at it literally, it still reads the same thing. But when it comes to interpretation of the Supreme Court, how does the Supreme Court interpret it? The Supreme Court has interpreted it in this manner, that any act is not a criticism. If it is a criticism against the state, it does not mean that it is an act of sedition. If it is a criticism of the government, it does not mean it is an act of sedition. If there is certain processions, certain steps that are taken against a decision that the government has taken, it is not an act of sedition. However, if an individual performs any act wherein the individual tries to excite violence against the state, and this violence, eminent violence against the state with an objective of overthrowing the state, that is what is sedition. So the Supreme Court interpreted sedition and interpreted section 124A in a different manner and declared that sedition law is constitutionally valid. Sedition law is constitutionally valid. So why are we discussing it? Because the Supreme Court has already declared it to be constitutionally valid. So why are we saying that, why is there a need to discuss sedition law? The need arises because of the manner in which sedition law is used. The manner in which sedition law is used. Sedition law, the objective of sedition law, the manner in which it is used by the government, or more appropriately, the manner in which it is misused by the government. This is what we need to look into. Because there have been cases in which not only is the individual or the group of individuals punished because, there is a sedition case registered against them. Not only it's not just because of the fact that the individual has performed such an act. This is there to curb dissent against the government. If the government has taken up any particular step and there is a criticism that happens of that particular step, it is considered to be sedition. That is what is considered to be sedition. This is how it has been misused. Like if you take examples of what happened in Tamil Nadu, wherein there was a protest that was going on against the establishment of the nuclear power plant there. Now it was for those individuals who entered into such protests, sedition charges were levied against them. Sedition charges were registered against them. Similarly, if you look at in tribal areas, you will find that in tribal areas the government, in taking up mining or acquiring land of people, and when they dissent against the government, when they criticize or when they take up certain agitation against the government, there have been cases in which sedition charges have been registered against the whole village, not just one individual, but against the whole village as well. However, if you look at the law itself that is there, the law itself has been significantly interpreted in such a manner that now it cannot be considered as it cannot be considered as what you can say a law that is unconstitutional, because the Supreme Court has already declared it to be constitutional. The problem with this is that sedition is a cognizable offence. What is meant by cognizable offence? Yes? Yes? It's not non-bailable. Cognizable means any for any individual who is registered, or any cognizable offence that is registered against him. In that case, the individual can be arrested. Now he is arrested and detained. For non-cognizable offences, they are not. Individuals are not arrested and detained. But cognizable offences such as when we talk about offences such as rape, murder, etc., in which an individual who is alleged to have performed any such act, because there is a cognizable offence, it is considered to be a cognizable offence, the very first thing is that he is arrested. He is arrested. But that is not the case, or that is the case when it comes to sedition charge as well, which means whether the charges are legitimate or not, whether the charges are registered in it is registered under an act of sedition, or it is just registered for misuse of the law, still you would find the individual is arrested, the individual is detained, and that itself is a problem. So the problem with sedition law no more is about the constitutional validity of the law, it is how the law is implemented. It is how the law is implemented. You will find that there are number of cases in which even today there is a literal interpretation of the law. Despite the fact that in the Kedarnath case, the Supreme Court has significantly altered the definition of sedition, but even today it is still literally interpreted, and that is the reason why there is a need to take up certain steps. There is a need to take up certain steps so that how the law is being misused, that needs to be curbed or stopped. Clear? So what are those steps? We will look into those as well. What are the steps that you can suggest? If suppose the question comes on suggestion, what are the steps that you can suggest? So you can write some of these provisions as well. Have you understood the law? Have you understood the basic ideas? When you are giving examples, of what amounts to sedition and what is not, don't write about JNU as a what you can say misuse of the law. It was not the misuse of the law specifically when it comes to JNU. There are number of other examples that you can write. If you are reading the newspapers, you will get number of recent examples. Don't quote JNU. Clear? There is a case of sedition there, and it is very likely, it is under right now it is sub judice. And if you look at the bail provisions, etc., that has been given to the concerned individual, there are some very important charges that have been levied against individuals. So don't give an example of JNU. Clear? You can give other examples. Don't give an example of JNU. Okay? If you look at, if you just search this particular provision on the internet, you will get a Wikipedia page on it, and on that Wikipedia page you get number of examples. You get what Gandhiji had to say, you will get what Bal Gangadhar Tilak had to say about the law. You can go through it, you can quote those as criticisms of sedition law, but don't give an example of JNU. Clear? Write down. Yes, against the state, not against the government. See, inciting violence against the government that has been established by law it will be considered as sedition as well. Though if you look at the Supreme Court's exact wording, what did the Supreme Court actually say in that particular case? It said violence against the state. So when we are using the term state, it is a bit more comprehensive than the term government, which means if you are inciting violence against any authority of the state, that will be considered as sedition. So when we say government the government will also fall under the state, the term state. So legislature, judiciary, as well as the executive. So any such bodies will be considered as as the state basically. Okay. So if you are criticizing the government, that is absolutely fine. Criticism of the government is absolutely fine. But when you incite violence, when you specifically in your speeches or whatever you have you are writing, if you are talking about violence against the state, now that will be considered as sedition. Clear? you have already written the definition of sedition, what section 124A says. So we are going to look at it from two angles. First of all, the criticisms of the law, and then we are going to come to what the Supreme Court has to say and what should be done. Clear? First start with criticisms of the law. First, it is a pre-independence law. It is a pre-independence law used by the Britishers to suppress the freedom movement, and the same law is being used against our own people. Second, sedition law has been implemented in such a manner that any criticism against the government, or a political functionary is considered under the definition of sedition. Third, more importantly, the act is used to contradict or deprive freedom of speech and expression, which is a fundamental right, Laws such as sedition empower the executive in such a manner that deprives citizens of their fundamental rights under Article 19 and 21. Next, in more than 95% of the cases registered, for sedition are dismissed in the very first hearing. Which points out to the misuse of the law. This misuse deprives citizens of their basic rights, and contradicts the very essence of democracy, of democracy, that is criticism of arbitrary actions of the state. Arbitrary actions of the state. In brackets you can write presence of a limited government. Presence of a limited government. Which means what, you know? If I tell you to distinguish between a arbitrary or a non-democratic state and a democratic state. Now, if I tell you to distinguish between them, non-democratic state and democratic state, the only or the most important distinction here is, in a democratic state, people are going to enjoy some rights which are not there in the non-democratic state. Some not just basic rights, but rights that ensure the presence of the rights that ensure the functioning of a democratic system, like freedom of speech and expression. Otherwise, it's not to say that in a non-democratic state people do not enjoy rights. If you remember, I gave you an example of China, wherein I said people enjoy two fundamental rights, right to work and right to a decent burial. So saying that they do not enjoy rights will not be correct. Yes, in a non-democratic state, people do enjoy some rights, but they do not enjoy more appropriately democratic rights. Rights such as freedom of speech and expression. So laws such as sedition does what? Laws such as sedition, it actually imposes a barrier in India's evolving, India evolving to a next level, next level of what is called as, next level of that idea of democracy. Because we should very much, the state should very much be open to any kind of criticism. क्या फर्क पड़ता है? Even if I come out with a right, if suppose I come up with some slogans, ठीक है, come out with certain slogans such as खालिस्तान जिंदाबाद, सुना होगा आपने, इस तरह के slogans. What is the difference? Now, does such slogan incite violence? No, it does not. Yes, when I take up slogans that are contradicting or that are challenging the sovereignty of India or territorial integrity of India, now that can be considered as inciting violence. Not such slogans. Even the Supreme Court has, the Supreme Court in one of the cases, Balwant Singh versus the state of Punjab case. In Balwant Singh versus the state of Punjab case, Supreme Court said, if an individual is taking up slogans or some group of individuals taking up certain slogans, but those slogans are not in the nature of inciting violence against the state, it is still their democratic right. It cannot be considered as sedition. So when we talk about the democracy, our democracy over a period of 70 years, over a period of 70 years and even further, there is a need to do what? There is a need to come up with some laws or amend such laws which somehow impose any kind of barrier in how our democracy has evolved or how it is going to evolve, like laws such as sedition. I am not saying that there should not be any law of sedition. There is a requirement of law of sedition, but how we implement them is important. Clear? Next, the Kedarnath Singh versus, or you can just give a subheading, right? Supreme Court's opinion, Supreme Court's view. First case, Kedarnath Singh versus the state of Bihar. Kedarnath Singh versus the state of Bihar. The constitutional bench of the Supreme Court the constitutional bench of the Supreme Court upheld the constitutional validity of the sedition law. However, the Supreme Court stated that an individual can be charged with sedition. An individual can be charged with sedition only if the sedition only if there is an incitement to violence in his speech and writing or with a tendency to create disorder and disturbance in law and order. Next paragraph. In the Menka Gandhi versus the Union of India 1978 case, Menka Gandhi versus the Union of India 1978 case, the Supreme Court stated that criticizing and drawing general opinion against the government, their policies and decisions, within a reasonable limit that does not incite rebellion against the state, is consistent with freedom of speech and expression. Now, you can give a subheading suggestions. This Menka Gandhi case that is there, I am going to discuss it at length under Article 21. Suggestions. First, amending the law to incorporate Supreme Court's opinion. Second, training of police personnel to limit the misuse of law. Third, making it a non-cognizable offence. Thereby requiring the permission of a judicial magistrate. Permission of the judicial magistrate before making an arrest under sedition law. Clear? So if it is made a this should be very clear. What is cognizable and what is non-cognizable? What is cognizable and what is non-cognizable? See, if you make an offense a non-cognizable offense, in that case, arrest of an individual can be done only with a prior permission of a judicial magistrate. Whereas in cognizable offense, no such permission is required. Because currently it is a cognizable offense, what happens is that no such permission is required from a judicial magistrate, and hence the police or the executive acts according to what they want. According to what they want, how they want it. Now, with making it a non-cognizable offense, what would happen is that arrest would still be permitted, but there would be a check and balance imposed on the power of the executive. And how would it work now? It would work now by or through this mechanism. If you want to arrest an individual under sedition, you have to have the power of a judicial magistrate. And when would the judicial magistrate give you permission to do it? The judicial magistrate would give you permission to arrest an individual in such offense only when you have performed an action which is under the definition of the Supreme Court, if it is something that falls under the sedition cases. So what would happen is misuse of the law very significant. Now there will be a significant reduction in the misuse of the law. Okay? So judiciary will act as a check on the power of the executive, how they are exercising such powers when it comes to sedition cases. Clear? Understood this? So with Supreme Court's interpretation of the sedition law, what has now this become? This is now a reasonable restriction under Article 19(1)(a) of the Constitution. With Supreme Court's how the Supreme Court has interpreted the law. Otherwise, yes, it is a draconian law. Otherwise, why? Because it is depriving citizens of their fundamental right to freedom of speech and expression. Clear? Clear? Now, if you get a question on sedition, it will be absolutely clear what is to be written, what is not to be written. Now, I have dealt with this idea of cognizable and non-cognizable offense because this is something that is a bit technical, and generally if you are a lawyer you understand this, but if you are not, you don't get this idea. And this is frequently used even when you are going through newspaper, this idea of cognizable and non-cognizable offense is frequently used. Clear? Next, defamation law. More appropriately, it is anti-defamation. Section 499 and 500 of the IPC. Section 499 and 500 of the IPC. So, see the discussion on anti-defamation law is also something that is very similar to a discussion on sedition. Why? Because the ground of criticism of this particular law is also very similar, that it is contradictory to the idea of Article 19(1)(a). Basically, there are two things before I get into this. What is all this? What is defamation or anti-defamation law all about, and what is the problems here? You need to understand why this particular law has been in news. Over the past 4 or 5 years, there have been number of cases in which political personalities, there have been political personalities and anti-defamation law being registered or charged against them. If you take an example, it started with Arvind Kejriwal, wherein Arun Jaitley registered a case of defamation against Arvind Kejriwal because Arvind Kejriwal had alleged that there are the Arun Jaitley, when he was the president of the Delhi Cricket Association, so there were some cases of corruption, of land grabbing, etc., that he accused he alleged that it was Arun Jaitley who was involved in it. In his political speeches, he talked about it. Arun Jaitley registered a case of defamation against him. And defamation in India is both a civil and a criminal liability. Both a civil and a criminal liability. Now, civil liability means what? Civil liability means, and for which you may have to pay a compensation against to that particular individual. Like whenever we talk about cases of property or something like that, they are all civil suits. Even Ayodhya case or the Ayodhya verdict that was there, it was a civil suit. It was not a criminal suit. Why? Because there was a disputed land, and land or such things that are there, they are under civil suits in India. So it is a civil suit as well. But in India, we also have provisions of criminal defamation, which means if you look at section 500, section 500 prescribes punishment, and it says any individual who is convicted for defamation or under defamation laws, he is liable to serve a sentence of 2 years. He is liable to serve a sentence of 2 years of imprisonment, because only in criminal cases you are convicted and you are liable to serve sentences like imprisonment, etc., not in civil suits. Civil suits are like you may have to pay a compensation or something like that. So not only did Arvind Kejriwal register a criminal defamation case against Arun Jaitley registered it against Arvind Kejriwal, but also a civil suit of 200 crores. Now he said that he has not only criminally defamed me, but also a civil liability of 200 crores was imposed. Similarly, if you look at cases wherein there are 2 or 3 other cases that you must have heard about. Very recently, Rahul Gandhi was present in in Maharashtra. He had to appear in a case of a criminal, again this defamation cases. Why? Because he had alleged in one of his political speeches, in his political rally, he said that RSS killed Gandhiji. So RSS filed a defamation case against Rahul Gandhi. Not only that, in another case, there was a case registered against Rahul Gandhi wherein he said, "Sare Modi chor hote hain." ठीक है, he said this. So there was a defamation case that was registered. एक बोलते उन्होंने ये कहा था क्योंकि नीरव मोदी एंड ललित मोदी that was the case, and he said that सारे मोदी चोर होते हैं. So there was a defamation case that was registered against him in that case as well. Similarly, during these elections, general elections that were going on in East Delhi constituency, what had happened was the Aam Aadmi Party had alleged that Gautam Gambhir had circulated they had come out with a pamphlet in which they had made certain remarks against the candidate, the Aam Aadmi Party candidate, and also against individuals, some leaders of the Aam Aadmi Party like Manish Sisodia and Arvind Kejriwal. When there was a press conference held, and in that press conference, they talked about it. The next day, a defamation case was registered against all the members of Aam Aadmi Party who were involved there by Gautam Gambhir. He registered an defamation case because there have been number of cases in which defamation has been the cases of defamation that has been registered. And if we go back to last in the year 2015-16, Actually, there was a hearing of the Supreme Court, and the Supreme Court was hearing this matter, that whether defamation or the law that is there, this is section 499 and 500, can this defamation or can the criminal, can we do away with the criminal liability that is imposed? Because there has been, if you look at the current scenario world over, you would find that defamation is not considered to be a criminal offense. It is considered to be a civil liability. It is considered to be a civil liability. Yes, it is an offense, but it is a civil offense, not a criminal offense. This is something that goes on world over. No, it is a practice that is there. In fact, if you go back around 5-6 years, there was an organization, and UN-led organization, which called upon the countries, the members of that organization, to decriminalize defamation. On this particular hearing, the Supreme Court declared the criminal defamation as constitutionally valid. Said that no, criminal defamation is constitutionally valid. It is not unconstitutional. Why? Because under Article 21 of the Constitution, every individual has right to life. Life means what? Dignified life. And for a dignified life, reputation is very important. And hence Article 21 of the Constitution, that is right to a dignified life or right to reputation, which is a part of Article 21, is it will act as a reasonable restriction under Article 19(1)(a) of the Constitution, which provides us freedom of speech and expression, but it does not provide us the right to defame anyone. So the Supreme Court also heard this matter, and the Supreme Court also declared it to be constitutionally valid. एक technical point इसमें ये है. If you look at the defamation charges that are there, in India it is a criminal offense. And when we say it is a criminal offense in India, what does that mean? ज़्यादातर ये political, you would find that it is used against political personalities like राहुल गांधी, अरविंद केजरीवाल, इन्होंने कुछ बोला, या आम आदमी पार्टी के कुछ members ने बोल दिया. So it is used against political personalities. And the Section 500 says that any individual who is convicted under 499, Section 499, and he is liable to he is liable to, or she is liable to serve a sentence of 2 years or more. That 2 years that is there, 2 years, the idea that is there, it is also politically important. Why? Because if you look at the Representation of People's Act, Representation of People's Act say any individual who is liable to serve a sentence of 2 years or more, 2 years or more, and has been convicted in a criminal offense cannot contest elections. That means the individual is automatically disqualified from the legislature. If he is a member of the legislature, he is disqualified. He has to resign from the legislature. Even if he does not resign, his seat automatically falls vacant. His seat automatically falls vacant. Clear? His seat is automatically vacant. And for further, that means he will serve a sentence of 2 years, and he will be disqualified not just for 2 years. He will also be disqualified for the coming 5 or 6 years. There is this 5 or 6 years has been mentioned, which means in total he is disqualified for 7 to 8 years. And that is the reason why it has some political consequences as well. And because of this idea of a defamation, this case of defamation that is there, it is also it has been in news. Supreme Court has declared it to be what you can say constitutionally valid. Clear? But what are the arguments in favor and not in favor? There are two things that you need to understand here. First, the debate is not about constitutional the constitutional validity of the defamation law. There are two things there are two debates here. First is about decriminalizing defamation. क्या हम ये कर सकते हैं? Should we go for it? Should we decriminalize defamation? The first thing is that. Second of all, we also need to see whether defamation is contradicting our constitutional fundamental right under Article 19(1)(a). There are two things here. So under Article 19(1)(a) that is there, the Supreme Court declares that it is no more. Everyone has the right to reputation under Article 21. It is a reasonable restriction on Article 19(1)(a). So when it comes to constitutional validity of defamation law, it has been upheld by the Supreme Court. But the debate of decriminalizing defamation is still going on. So what are the arguments in favor and against it? Let us discuss that. Have you understood what is defamation? So let's start with what section 499 and 500 says, and after that we go to the next discussion. You can write first section 499 and 500. 499 and 500. Under section 499, whoever by words either spoken or intended to be read or by signs or by visible representation makes or publishes any imputation concerning any person intending to harm or knowing or having any reason to believe that such imputations will harm the reputation of a person has defamed that person. Next you can write under section 500, whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years or a fine or both. Clear? So this is the definition of defamation and section 500 prescribing the punishment for individual who is convicted under section 499. Clear? Next, give a subheading, right? Why defamation should remain a criminal offence? Why defamation should remain a criminal offence? So there are two arguments here. Why? In favor and against. No, in favor and against. Why defamation should remain a criminal offence in India? I am assuming that you have read about defamation, क्योंकि मैं पिछले क्लास में बोल के गया था कि पढ़ के आना. चलो इस तरह से समझते हैं. If you look at defamation in India and if you look at cases of defamation in US, let's compare it. Defamation in US is a civil offense. It is an offense, it is a civil offense. And defamation in India is a criminal offense. Along with that, it is civil as well as a criminal offense. Why not we should amend this idea of, why not we should amend this idea of defamation being a criminal offense, and section 500 should be amended, and in section 500 that imprisonment, 2 years of simple imprisonment that is there, it should be, that provision should be amended, and there should be a provision of civil, that is the individual is liable to pay a fine. My question is, why is it, if I say it is appropriate in US but it is not appropriate in a country like India, why? Why do you think can be a reason for it? Why is there a need to continue with criminal defamation in India? किसी भी लॉ का प्राइमरी ऑब्जेक्टिव क्या होता है? एक बहुत ही सिंपल क्वेश्चन पूछ रहा हूं मैं आपसे. यस, डेटरेंस क्रिएट करना. क्लियर? किसी भी लॉ का प्राइमरी ऑब्जेक्टिव is not to punish an individual. It is not to punish an individual. It is to create a deterrence. It is to create a deterrence. If you can ensure that you come out with laws which are, which are successful in creating deterrence, that is the ultimate goal. That is the ultimate goal. Recently you must have heard about the Motor Vehicles Act and the amendment in the Motor Vehicles Act, and the new fines that have been imposed under the Motor Vehicles Act. और उसमें बहुत इंटरेस्टिंग न्यूज़ भी आने थे. ठीक है, कि एक स्कूटी वाला था गुड़गांव में, he had to pay a fine of 30,000. तो कह रहा था 15,000 का मैंने स्कूटी लिया था, 30,000 मैंने फाइन दिया है. ठीक है. Similarly, what is the objective? Do you think the objective is to impose more and more fines and collect that by the state? No. The objective is that when it comes to creating deterrence, it should be creating deterrence. I think 3 दिन पिछले हफ्ते का न्यूज़ था that there was an individual in Gujarat जिस पे 9 लाख रुपए का चालान. He had to pay 9 lakh rupees. ठीक है. What is the objective? Do you think collecting 9 lakh rupees is the objective? No. Ensuring that if the individual has performed that particular offense, once the individual has performed that particular offense, he is charged in such a manner that he will not do it later on. It would create a deterrence. This is the ultimate objective of the law. So when we talk about criminality of or making defamation a civil offense and not a criminal offense, my question now is, do you think it will create deterrence? If not, why? I have answered the question for you. By paying money. Don't you think fine itself is a deterrence? Not in India. क्यों? बहुत पैसा है लोगों के पास. They can easily pay fine. देखो, you cannot actually, for something that is a personal, it's not against a political party. When the charge is not against a political party, you cannot use public funds or political funding for personal expenses. वो नहीं कर सकते हो आप. चलो, दो एग्जाम्पल्स देता हूँ. Around 3 years ago, I read a case in which there was a civil dispute that was filed. The case was filed in the year, no, the case was filed in the year 1965. The case was filed in the year 1965. Supreme Court's judgment comes in 2015-16, almost after 50 years. जिसने वो केस फाइल किया था, she was a woman, she died. And the Supreme Court imposed no, what you can say, compensation that the Supreme Court provided to the individual was 50,000. ठीक है? The Ayodhya verdict, again a civil case, continued for how much years? No, how many years? It is a 130-year odd dispute. अगर इंडिपेंडेंट इंडिया की बात करते, द केस वॉज फर्स्ट रजिस्टर्ड आई थिंक इन 1956. द फाइनल डिसीजन कम्स इन द ईयर 2019. डू यू थिंक इफ इट रिमेन्स अ सिविल ऑफेंस, इज इट अ डेटरेंस देन? नहीं, देन इट इज नॉट अ डेटरेंस एनी मोर. अगर मैंने ऐसा कुछ किया, मेरे अगेंस्ट किसी ने फाइल कर दिया सिविल डिस्प्यूट, आई नो इट इज इन माई लाइफ टाइम तो डिसाइड नहीं हो रहा है, मेरे लाइफ टाइम में तो डिसाइड नहीं हो रहा है. ठीक है, इट इज नॉट टू बी डिसाइडेड इन माई लाइफ टाइम. 50 years, आई एम नॉट गोइंग टू लिव 50 years फ्रॉम नाउ. इफ आई लिव, आई डोंट वॉन्ट टू. ठीक है, मतलब सही नहीं होगा वो. सो दैट इज द केस, दैट इज द केस. सो हाउ विल इट बिकम एन इफेक्टिव डेटरेंस when it comes to a country like India? Secondly, deterrence तब भी हो सकता था if the compensation paid or the compensation ordered, if it is huge, if the compensation ordered is huge, that will also likely to create a deterrence. But in a country like India, जैसे मैंने आपको example दिया of a civil suit, 50,000 almost after 50 years आपने 50,000 रुपए का कंपनसेशन पे करने के लिए कहा. 50,000 आफ्टर 50 years. Now how can that create a deterrence? How can that create a deterrence? Question तो ये है ना, how can that create? Now if you look at US, if you compare countries such as US, in US compensation is not so small. Compensation is millions of dollars. There are cases in which, there was a case in which a particular company, I remember I was going through a case, there was a company who was discharging waste, discharging their industrial waste in a river, which seeped into the water, the drinking water drainage system that was there, the system, and it led to some 14 families of a particular area. They were, in their families, the children that were born, they were born with deformities because of it. The court in US, that particular court, they came up with a charge to pay $800 million as compensation to that 12 families. $800 million अगर कैलकुलेट करोगे ना, तो आपका कैलकुलेटर उसका जवाब नहीं देगा, एरर दिखाएगा. This is the kind of compensation that is paid there. In India, compensation is 50,000. How can that be an effective deterrence? Wherein there you are paying compensation which is worth millions of dollars, hundreds of millions of dollars. If the individual is likely, if the individual is likely to, if the individual is capable to pay, they are told to pay millions of dollars worth compensation to any individual who has filed a civil suit or something like that. Now in those cases it is a deterrence. And the judicial system does not work in this manner, how it works in India. Pending cases. Now there are, in the Supreme Court itself, it says that if the Supreme Court works every day and allots around 1 minute's time to each pending case, it will take the Supreme Court 20 years to resolve all the cases that are pending before the court. 1 minute, 1 minute अगर आप देते हो हर केस को, and you are working every day, it will take the Supreme Court 20 years to resolve all the cases that are pending. So you can understand, now you can understand the problem of making defamation a civil offense. There will be no deterrence. The idea of deterrence, which is the primary objective of any law, that is itself lost. Clear? So when we say why it is not made a criminal offense, it is this. And also in India, there is also political usage होता है इस तरह की चीज़ों का, you know, with the primary objective. देखो आपने इस तरह की चीज़ें, इस तरह का आपने political idea शुरू किया. जैसे राहुल गांधी ने बोल दिया सारे मोदी चोर हैं, और उन्होंने इलेक्शन कैंपेनिंग के टाइम पर एक फ्रेज जैसा शुरू किया था, ठीक है, चौकीदार चोर है, इस तरह का. देखो इस तरह की जो कुछ चीजें होती हैं, द ऑब्जेक्टिव इज टू गेन सम काइंड ऑफ माइलेज देन एंड देयर. If you don't allow it to be a criminal offense, if it is a civil offense, because of the time period that is required to resolve such, उनको political mileage तो मिल गया, हो सकता है. No, it may so have happened that because of this very idea, कुछ ऐसे voters थे who were likely to vote for a political party, voted against the political party. No, voted against the yes, every political party has the right to do it. Every political party, in fact, the very objective of political party is to contest elections, come to power. No, and how would they come to power? No, by talking about their ideology, by spreading that. That is the right that every political party has. Even as an individual, as a citizen. So if I am likely to vote for a political party, I have decided that I am going to vote for a political party, but every political party has the right to come up with their policies, to project their policies, to project their political party's ideology. Everything is that fine, absolutely fine. But the problem with defamation is that it is not just about political. It's not about political ideology. You are targeting an individual, because defamation charges are against individual. If you look at the definition says against an individual. It is not about a political party. It is not against a political party. It is not against the government. The Supreme Court, in the decision, right to reputation case that we were talking about, that in which it declared that it is not a violative of Article 19(1)(a), the Supreme Court said the government does not have the right to of this idea of reputation or defamation. The government cannot do that. Why? Because the government has the necessary resources to defend itself. So you are in power, you have the necessary resources. If someone is accusing or alleging you of something, you can come out with facts and dispute that particular whatever allegations have been imposed on you. So you have the necessary resources. So you do not have the defamation law. You cannot use defamation law. Government cannot use that. It is only about individuals. It's only about individuals. Or when you use you target individuals on the basis of giving them group identity, like talking about Modis or talking about RSS as an organization. Now they have those rights. Government does not have that right. So when we talk about defamation, what is the problem of making it only a civil offense? Because if you compare other countries, if you compare India, if you compare the judicial system that is present in India, if you compare the judicial system present in those countries, if you look at the kind of compensation that is paid in India, compensation that is paid in those countries, you will find that if you make defamation law a civil offense, it would not be an effective deterrence against defamation. It would lose the very idea, the power of deterrence. It would lose that. and that is the reason why when it comes to arguments in favor of why it should remain a criminal offense. Clear? Clear? Write this. Arguments in favor. First point. The objective of any law is to ensure that it acts as a deterrence, by amending the defamation law and making it only a civil offense. It is likely to lose the power of deterrence. Second, criminalization of defamation is a part of states' compelling interest to protect the right to dignity and reputation of its citizens. Third, unlike other countries, defamation in India cannot be treated only as a civil liability, as there is always a possibility for the defamer to be judgment free. In brackets you can write, because of delays in the judicial process, comma, the lack of imposition of extraordinary compensation and inadequate financial capability to compensate the victim. This is also one of the ideas, and you will find, if like political personalities itself, in terms of whatever assets they have, if you look at the declaration of assets that they do, they tend to not hold assets in their name. So even if you impose certain fines, that you have to pay a fine of suppose 5 crores. Now the individual does not have 5 crore as personal property. वो कहेंगे है ही नहीं, कहाँ से पे करेंगे? So judgment free हो गया ना फिर तो. Clear? So that is also one of the reasons. And one more point you can write here. Besides, section 499 and 500 cannot be considered as obsolete cannot be considered as obsolete in a modern democratic polity. Modern democratic polity as under the IPC there are 10 exceptions. There are 10 exceptions including truth, to defamation. So there are exceptions also, like truth, any truth that is in public interest, any truth spoken that is in public interest in good faith is considered to be an exception to defamation. It is not considered to be defamation under defamation laws. Clear? But the most important argument or the most important part of our discussion is the arguments against criminality of defamation. So you can write this: arguments against criminality of defamation. You might get a question wherein you are asked this specifically: why should we actually decriminalize defamation? Arguments against criminality of defamation. First point: truth is also not a defense, under defamation, as the law says truth spoken in good faith and in public interest. In good faith and in public interest. So truth is also not a defense. Truth is any kind of truth that you have spoken in public interest is only an exception. Public interest, the key point being public interest. So is public interest defined under the law? No, it is decided by the judiciary. What is public interest? इस बात को अच्छे से समझो. What am I saying? I am saying that if you are to be prosecuted under defamation laws and you say that whatever I have spoken is the truth, even if you have the necessary information to prove what you have spoken as truth, it is not a valid defense. Until unless you have spoken truth in public interest. If it is considered that you have spoken the truth and it is in public interest, only then that is that is an exception and valid. Otherwise it is not a valid defense. Now what is public interest? Public interest is decided by the judiciary. It is up to the judge who decides whether you have spoken the truth in public interest or not. If you have spoken the truth in public interest, he says you have spoken the truth in public interest, only that is a valid defense. समझ रहे हो ना? सच बोलना भी valid defense नहीं है जब तक आपने सच public interest में नहीं कहा है. जब तक आपने सच public interest में नहीं कहा है. So if suppose I am speaking about some individual, so in that case that individual can sue me for defamation. I have to prove that what I am speaking is the truth and it is in public interest. ठीक है? Who decides what is in public interest? The judge. Subjective हो जाता है फिर. There is no objective definition of public interest. अगर objective definition होता तो फिर भी चल जाता, लेकिन कोई भी objective, there is no objective definition of what is public interest. Second, critics argue that that the defamation law encroaches upon the fundamental right to freedom of speech and expression, and that civil defamation is an adequate remedy against such wrongs. In brackets you can write here, however, it is a counterpoint. However, the Supreme Court has upheld the constitutional validity of criminal defamation by stating Article 21, which provides an individual with the right to life, to be read as dignified life, and reputation being an inherent right under Article 21, thereby declaring Article 21 as a reasonable restriction on Article 19(1)(a). Clear? This is Supreme Court's opinion. Okay? Next. Many countries worldwide are in favor of treating defamation as a civil wrong and not a criminal offense. Next, the misuse of the law as an instrument of harassment, as prosecutors complain is taken at face value by court, the court, which sends out routine notices for appearances without any preliminary examination without any preliminary examination. Preliminary examination. Thus, the process itself becomes a punishment. The process itself becomes a punishment. You have to appear in the court. It is mandatory in such cases. So because you have to appear in all the hearings of the court, the process itself becomes a punishment. Next. Also, criminal defamation should not be allowed as an instrument, in the hands of the state, as the procedure gives public servants an unfair advantage. And the last point, defamatory acts which harm public order, are covered by section 124, 153 and 153A. 153 and 153A. Therefore, there is no need as it does not serve public interest. Section 124 and 124A, sedition, we have already seen it is contrary to public interest, punishable. Section 153 deals with hate speeches. Section 153, 153A deals with hate speeches, and they are also a punishable offence under a different section of the IPC. Clear? And different laws like Representation of People's Act. Representation of People's Act, there is a provision under Representation of People's Act, section 125 clause 5, which also deals with this idea of hate speeches. So because there are other provisions in various other laws or in the IPC which already provides for any kind of defamatory acts which are contrary to public interest, if those acts are, or those laws are there and those laws are already present, they make it a criminal offence. There is no need for section 500 or section 499 to be a criminal offence, because it has already been provided somewhere else. Clear? So hate speeches, those things like any such idea can also, if you have followed general elections, you must have seen that during the election campaigning, any such acts to communalize or any such speeches which are directed against a particular section of the society on the basis of religion, caste, etc., they are not permitted. And if any individual takes up any such act, they are punished by the election commission. If you remember, during the early phases of our elections itself, this general elections itself, Mayawati and Yogi Adityanath, there were some complaints against them, like Mayawati specifically targeted a particular religious community, saying that they should vote for us. And similarly, Yogi Adityanath replied in the same manner, trying to communalize the election. Now they were barred from election campaigning for a certain period. And if this attempt that is there to communalize, or against a particular section of the society, in that case it might result into, election commission can take up whatever steps, Now, when we come to our discussion on election commission, you will find that election commission is a quasi-judicial body having the power, judicial powers also, to punish an individual if they are violating such norms or such conduct norms or model code of conduct that is there. If there is a violation of it, election commission has the power to punish an individual, like they did when it came to a speech that was given by Mayawati, and similarly a statement that was made by Yogi Adityanath. So those things are already present, hate speeches or those ideas that are there, they are already present. In last general elections, what happened was that is 2014. In one of the election rallies, Mulayam Singh Yadav made a very controversial statement. In what he said was, in cases of rape, etc., he was making a statement there, and he said, "Galti ho jati hai," something like this. And for that, again, election commission also, election commission acted, and election commission prohibited him from campaigning for a few days. Such laws, such provisions are there in our laws. So there is no need for making it a criminal offense. Clear? So this is the idea. When it comes to constitutional, see, I am repeating it again. Because this is a mistake that you tend to do, because if you do not have a proper understanding of things. When it comes to constitutional validity of defamation laws, constitutionally defamation laws are absolutely valid. Supreme Court has declared it to be the part of reputation, right to reputation under Article 21. When it comes to criminal defamation, yes, the debate is about whether we should continue with criminal defamation or we should do away with this idea of criminal defamation. It is not about whether criminal defamation laws are unconstitutional. No, Supreme Court has upheld the constitutional validity of those laws. The debate is about whether we should continue with the criminal defamation or we should amend section 500 and make defamation only a civil liability, not a criminal liability. The debate is about this. So whatever you read in the newspapers, it would be about this debate. Anything that comes up very recently, because I read it in the newspaper a day before, when Rahul Gandhi had to be present in one of the Maharashtra because of this very defamation. So there was a good article on defamation the next day. So when you read about such things, you would find the focus is about, the debate is about criminality of defamation, not anymore about legality or constitutional validity of defamation. Clear? Absolutely clear? So coming to the last part of our discussion here, that is suggestions. Suggestions. What can be done? First, truth should be made a viable defense. Truth should be made a viable defense in such suits, such cases. Second, court should also be empowered. Court should also be empowered to impose exemplary punishment. Exemplary punishment on frivolous, FRIVOLOUS, frivolous suits, frivolous cases. Third, to ease the burden of the judiciary, it is vital that court are required to only hear serious defamation cases. Next, limits should be placed around civil defamation. That is, not only must the loss to reputation be serious, not only must the loss to reputation be serious, but the proof must also be substantial. These are certain things that can be taken up. Substantial means when you talk about defamation, to ensure that it works properly, what should be done is there should be some limits that should be imposed. Like, as an individual, if I allege that you have just taken up or spoken or done something that is, that has ruined my reputation, in that case I should also have I should also have necessary important proof, substantial proof, to prove that this, there is a loss to reputation, and this loss is, it is a great loss. Frivolous चीजें नहीं होनी चाहिए कि बस for the sake of defamation, harassing an individual or something like that. That should not be the case. Clear? With this, we complete our discussion on Article 19(1)(a) of the Constitution. ठीक है? Sometimes there is an additional topic that comes up from time to time on this very idea. इसके कुछ examples है. जैसे if you go back a few years, there was a case in which in one of the comedy shows that is taken up in the इस तरह के serials वगैरह जो आते हैं, there was an individual who portrayed Baba Ram Rahim, and he was there was a complaint that was registered against that individual under section 295A of the IPC. Section 295A of the IPC, which deals with what, this section 295A of the IPC deals with hurting religious sentiments. It deals with hurting religious sentiments, and this is also considered to be a restriction on our freedom of speech and expression. Why? Because when we talk about religion or taking up any such ideas, we have to be careful whether a particular community, their religious ideas that are there, they are not heard. Or India mein we are very sensitive towards these ideas. Okay? We are in terms of communal harmony, with these things, communal harmony etc. are disturbed. So section 295A, it tends to come to news sometimes, not always. कुछ ऐसा हो जाता है. In that case, it is done. There was a law that was proposed by the Punjab government. I think it was the Punjab government, wherein they wanted that this section 295A should be amended, and any kind of religious documents that are there or religious books that are there, any kind of defacement or any kind of action, any such action that was taken against such religious books or religious any such thing that is there, it should be punishable by death. उन्होंने ये propose किया था, it should be punishable by death. Again, going back 2 or 3 years, ऐसा कुछ हुआ था. Now, there was in one of the gurdwaras, there was defacement of the holy literature that is there in Sikhs. ठीक है, उस ग्रंथ साहिब जो थे उसमें कुछ किया गया था, and they had proposed this very idea. But obviously, it will be unreasonable. Now, it would be unreasonable to amend it in such a manner that it leads the punishment is death. So it was not taken up, but they proposed it. And it was under this again section 295 because it hurts religious sentiments etc. etc. Okay? With this, we complete our discussion on Article 19(1)(a) of the Constitution. Next is Article 19(1)(b). Next is Article 19(1)(b). Article 19(1)(b), what is it? Write down. It guarantees the right to assemble peacefully without arms, So we along with the fundamental right to freedom of speech and expression, we also have the fundamental right to do what? We also have the fundamental right to assembly without arms, that is peacefully without arms. Which means what? If you look at Article 19(1)(a) and if you look at Article 19(1)(b), Article 19(1)(a) and Article 19(1)(b) is complementary to each other. Because if I talk about freedom of speech and expression, तो freedom of speech and expression मैं खाली हॉल में तो नहीं बोलूँगा ना. That is not my, that will not just be my freedom of speech. That I can talk to myself. ये तो नहीं होगा ना freedom of speech. Freedom of speech and expression means I can express myself to a larger crowd. I can talk about a particular idea or some religious views, or for that matter some political views that I have, not just with me but also for others. I have the right to portray, or I have the right to express myself in this particular manner. So it is complementary to each other. We say Article 19(1)(a) and Article 19(1)(b), they are complementary to each other. Okay? Next, Article 19(1)(c), very important. Article 19(1)(c), it guarantees the right to form associations, right to form associations or trade unions, or unions, sorry, don't write trade, just write union, or unions and cooperatives in brackets, right? The term cooperative was added by the 97th Constitutional Amendment. 97th Constitutional Amendment Act 2012. So the term cooperative was later on added to our constitution. Initially it read only as right to form association and unions. Now what is the meaning of the term association and what is the meaning of the term right to join association is what we are going to discuss tomorrow. Clear? This is a very important article. We are going to discuss this tomorrow. We are also going to talk about how civil servants have restricted political rights under Article 19(1)(c). Thank you.